My name is Jillian Malone, and this is my Terms of Use YouTube video. The first question is Priceline's user agreement a valid contract? Based on the information provided, Priceline's contract appears to meet the basic requirements for validity. However, the specific details and legal nuances of contract law may vary depending on jurisdiction and additional terms which aren't provided in our readings. So why is that? There is agreement. Users are informed that by accessing the Priceline's website, they agree they are legally bound to the terms of use outlined. This establishes mutual assent, which is a fundamental requirement for contract formation. There's also consideration. While consideration, which is something of value that is exchanged between the parties, is not explicitly mentioned in the excerpt, it is implied that users gain access to Priceline's services in exchange for agreeing to abide by the terms and conditions. There is legal capacity. The terms of use do not specify any restrictions regarding the legal capacities of the users, so it can be assumed that the users must have the legal capacity to enter into contracts. The legality of purpose. The purpose of the contract is to govern the use of Priceline's website and services, which is a lawful purpose. There is mutual assent. Both parties, Priceline and the users, demonstrate a mutual assent by agreeing to the terms outlined in the terms and conditions. And there are clear terms that are presented in the terms of use, outlining the rights and responsibilities of both parties, as well as procedures for dispute resolution. Are visitors bound by it, or do they have to click agree? In many cases, simply visiting a website does not constitute explicit agreement to the website's terms of use or terms of service. Instead, explicit consent is often required, typically through actions like clicking an I agree button or actively checking a box indicating agreement to those terms. What about Priceline in particular? In the case of Priceline's terms of use, users are informed that by accessing the website, they agree to be legally bound by the terms and conditions, which are outlined therein. However, it's common for websites to require users to actively indicate their agreement by clicking an I agree button before proceeding to use their services. This explicit action serves as evidence of the user's consent of the services. Therefore, while visiting a website may signal knowledge of the terms, users are typically required to take further action, such as clicking I agree to formally indicate their agreement and actually be bound by those terms of use. If you have a dispute with Priceline, can you sue them? Under Priceline's terms of use, users are generally not able to sue them in court for disputes. Instead, they are required to pursue resolution through arbitration, as outlined in the terms and conditions agreed to by using the website's services. According to Priceline's terms of use, if you have a dispute with them, you are required to resolve it through arbitration rather than traditional litigation in court. This is outlined in the arbitration and dispute resolution section of their terms of use. The terms state that any dispute or claim relating to Priceline's website, its services, or dealing with Priceline must be resolved through binding arbitration administered by the American Arbitration Association. The agreement further specifies that claims must be brought within a certain time frame and that arbitration is the exclusive method for resolving disputes. except for small claims court actions or cases involving certain types of injunctive relief. What changes would I recommend? If Priceline were considering to change its terms of use, here are some recommendations based on common user concerns and privacy. Best practices. One, the enhanced notice of arbitration clause. Make the arbitration clause more prominent and ensure that users are fully aware of their rights and obligations regarding dispute resolution. Consider using clear language and formatting it to highlight this section. 2, an opt-in agreement. Instead of automatically binding users to the terms and conditions upon accessing the website, consider implementing an opt-in agreement where users must actively consent to the terms of use before proceeding. This may involve requiring users to check a box indicating their agreement or providing pop-up notification requiring explicit consent. 3, transparency in pricing and policies. Ensures that all pricing, cancellation policies, and terms of service are clearly disclosed to users before they make a purchase. This can help resolve disputes and chargebacks related to misunderstandings about fees or terms. 4, the limitation on chargeback disputes. Clarify circumstances under which users can dispute charges with credit card companies and outline the process for resolving disputes with Priceline directly. Provide examples of valid and invalid reasons for chargebacks to help users understand their rights and responsibilities. 5, accessibility and readability. Simplify the language and the structure of the terms of use to make them more accessible to users of all backgrounds. Use plain language and avoid complex legal jargon whenever possible. Additionally, provide translations or summaries of the terms in multiple languages so to accommodate non-English speakers. And 6, regularly review and update. So commit to regularly reviewing and updating the terms of use to ensure that they remain current and compliant with relevant laws and regulations. Notify users of any material changes to the terms of use and provide them with the opportunity to review and accept the updated terms before continuing to use the website. And why? By implementing these recommendations, Priceline can enhance transparency, user consent, and overall user experience while reducing the risk of disputes and misunderstandings. Thank you.